Good afternoon. This is Dr. Sunidhi Kashyap, Assistant Professor, Maharaja Agrasen University, School of Law. Today we will be discussing about administrative law. In India, administrative law can be traced to the well-organized and centralized under the Mauryas and Guptas. The rule of dharma was in action. Davis, a well-known British scholar, said that administrative law existing long before the term administrative law came into use. So in UK and USA, how administrative law came into existence, we will know about it. In 1885, a British jurist, Justice A.V. Dicey, rejected the whole concept of administrative law. Hence, until 20th century, it was not given any regard in England. And in 1929, Lord Donmore Committee recommended for better publication and control of subordinate legislation. After that, the Crown Proceeding Act 1947 was passed. It allowed initiation of civil proceedings against Crown in a similar way as to any ordinary private citizen. The Tribunal and Inquiries Act 1958 brought about better control and supervision of administrative decisions. And in USA, it was ignored until the democracy came there. So there are various definitions given by the jurist. So the first and foremost important definition which was given by A.V. Dicey. He said that the administrative law is a portion of a nation's legal system which determines the legal status and liabilities of all states and liabilities of private individual in their dealing with public officials. Second foremost important definition was given by Ivor Jennings. He said administrative law is the law relating to the administration. It determines the organization, powers and duties of administrative authorities. And the last definition, which was important in administrative law, was given by K.C. Davis. He said that the administrative law is the law concerning the powers and procedure of administration agencies, especially the law governing judicial review of administrative actions. Now we will be discussing about doctrine of separation of power, which is the important part of administrative law. As we all know, powers are of three kinds, which was divided between legislature, executive and judiciary. So each of these powers should vest in a separate and distinct organ. Otherwise, there will be monarchy in the country. So separation of powers means three different things. Same person should not form part of more than one of the three organs. One organ of the government should not control or interfere in the exercise of function by another organ, and one organ should not exercise the function of another organ. Thereafter only we can say that the doctrine of separation of power is in existence. Otherwise, there will be no doctrine of separation of power. The theory of separation of power was included in Montesquieu in his book The Spirit of the Laws in the year 1748. He maintained that these three organs of the government must be vested in three distinct and different authorities if the liberty of the individual is to be granted, otherwise not. So he made a scientific division of the powers of the state as legislative, executive and judiciary. Having thus laid the foundation, he pointed out that there was no liberty when the legislature and executive powers were in one authority. That is, legislature should not be the executive and vice versa, that is, executive should not be the legislature. Again, there is no liberty if judiciary is not separated from the legislative and executive function. Till now, this theory has been admired in the country, as we all know that the independent judiciary has been in existence long time before. So if the judicial and legislative powers are joined, the liberty would be subjected to arbitrary control. Judge would be the legislature. If it is joined with executive, the judge might behave with oppression and violence. There would be an end of everything if all the powers are in one authority. This theory gained currency as it was based on the protection of individual liberty. The aim is not to create absolute barriers, but to impose mutual restraints in the exercise of powers by the three organs of the state, that is, parliament, executive, and judiciary. So, the US Constitution, how the doctrine of separation of power works. As we all know, that USA has been the best democratic country till now in the world. So how doctrine of separation works there? So the US Constitution in Article 1, 2 and 3, there vests the legislative, executive and judicial powers in the Congress, the President and the Supreme Court respectively. These are the subjects to checks and balances. And in its practical application, the theory means that the organic powers vested in one and should not be exercised by others. So in USA, we can see that there will be no interference of one organ into the another. The US Supreme Court, in its strictly sense, in the case Springer versus Philippine Island, said that the powers conferred on the legislature should not be exercised by the executive or the judiciary unless otherwise provided for or incidental. So Congress has powers to impeach the president who is directly elected by the people there. Senate has the executive power to ratify treaties, and Congress may delegate certain of its power to administrative authorities, etc. These are the examples to show that the doctrine has undergone modification. Hence, a rigid application of this theory could not be found in the US or in any constitution, as that would make it impossible to run the government. How doctrine of separation of power is working in England. So according to Garner, there is no sharing out of power in England, and as such separation of powers has no place in its strict sense. There are in England the three authorities: Parliament, Executive and the Judiciary. But there is no exclusive province to any specific authority. For example, the Lord Chancellor is the head of the judiciary and the chairman of the upper house and a prominent member of the cabinet, although it is not necessary. So the court exercises legislative powers when it is making the rules of procedure. Ministers make the subordinate legislation and also exercise quasi-judicial powers. The House of Commons has the power to investigate and punish for breaches of privileges of the House. Hence, this theory has no direct application on England. So, how doctrine of separation of power works in India? We have discussed about USA. We have also discussed about England. But what about our country? So in India, the constitution has vested the executive power in the president or the governor. There is no such vesting in the legislature or the executive. Article 51 enjoins separation of the judiciary from the executive. The Supreme Court, in the famous case, which is Reed-Daly Law Act case, which was passed in 1912, said that the essence of modern separation of powers was found in the concept of constitutional limitations and trust. How it is possible? It is possible when ordinance making power of the president was given in Article 123 of the Constitution, judiciary making its own rules of procedure, And thirdly, delegation of legislative power to subordinate law-making bodies, etc. So, in the famous case of Ram Joya versus State of Punjab, Supreme Court held that no organ of the state should exercise function that essentially belong to the other. And in Keshwanand Bharti case also, the court held that the separation of powers was part of the basic structure of the constitution, and even Article 368, it cannot be amended. Thus, Parliament should respect and preserve the courts. Courts should not enter into political problems, and such mutual checks and balances have become the core of separation of powers in modern constitution. So the sum and substance is that the essential functions of the legislature, executive and judiciary should not be exercised by the others. So, in crux, we can say that separation of power and its doctrine can only be successful when one organ of the government will not be interfere from the other organ of the government. So, evolution of Dicey thesis. In Local Government Board versus Ehrlich 1915 year and Board of Education versus Rice in the year 1911, administrative law could be effectively enforced by the courts as by body of men who combine official experience with legal knowledge, provided that they are entirely independent of the government. So, what about the modern concept? In the modern concept of the rule of law, it is fairly wide and therefore it sets up the ideal for any government to achieve. This concept was developed by the International Commission of Jurists known as Delhi Declaration 1959, which was later on confirmed at Lagos, Africa in 1961. In his According to this formulation, the rule of law implies that the functions of the government in a free society should be so exercised as to create conditions in which the dignity of man as an individual is upheld. So, this dignity, how it can be maintained? This dignity requires not only the recognition of certain political, civil rights, but also creation of wholesome, that is, certain political, social, economical, education, and cultural conditions which are essential to the full development of his personality and the protection of his dignity. So, this declaration put emphasis on independence of judiciary and effective government. In the famous case of Veena Sethi versus State of Bihar 1992, Supreme Court extended the reach of rule of law to the poor and the downtrodden, the ignorant and the illiterate, who constitute the bulk of humanity in India, when it ruled that the rule of law does not exist often merely for those who does not have the means to fight for their rights, and which protects and preserves their dominance and permits them to exploit a large section of the community. And the opportunity of this ruling was provided by a letter written by Free Legal Aid Committee, Hazaribagh, Bihar, which is now in Jharkhand, drawing its attention to unjustified and illegal detention of prisoners in jail for many years. So the commission, which was set up by the Free Legal Aid, have given so many recommendations. The first committee, which is on individual liberty and the rule of law, which laid down that the state should not pass discriminatory laws and that the state should not interfere with religious beliefs. It should not also place undue restriction on freedoms. The Committee on Government and the Rule of Law. This committee said that the rule of law means not only the adequate safeguards against abuse of power, but effective government capable of maintaining law and order. So, rule of law in this committee on criminal administration, here rule of law means fair process, no rigidity without the authority of law, legal aid, public trial and fair hearings. Only then we can say that the rule of law must be there. Next committee which was set up was Committee on Judicial Process and the Rule of Law. It means independent judiciary must be there, independent legal profession must be there, and the standard of professional ethics should be there. In the report of Secretary General of United Nations in 2004, they have also given so many things to our country. In his report, they said that the principle of governance should include the responsibility of all persons, institutions, public and private. It doesn't matter, but it should be there, and it includes the state to law, which is promoting equally enforced and is consistent with human rights, values, norms and standards. The second thing which was given in their report are the measures which are necessary to enforce these principles of governance, which include supremacy of law based on the above principles, equality before law and equal protection of law, which was given under Article 14 of the Constitution of India, fairness in the application of law, separation of powers, participation in the decision making and accountability of law. So, after doctrine of separation of power, we will be discussing about rule of law. In Sheila Bharse versus State of Maharashtra 1983, in this case it was held that the court said that the fairness to women in police lockup and drafted a code of guidelines for the protection of female prisoners. In next case, which is of State of Madhya Pradesh versus Ram Shankar Raghuvanshi. In this, the court secured fairness in public employment. In this, they said the efforts of the court under the legitimizing due administrative powers should be there, and it illegitimate undue powers. They said that the judicial activism should be there, and it will be firmly applicable to the concept of rule of law in India. Again, the dicey concept of rule of law should be accepted by all in India. It contains three principles. Dicey said that there must be absence of discretionary power in the hands of the government. Dicey by this implies that the justice must be done through known principles. No person should be made to suffer in body or deprived of his personal liberty except breach of law established in the ordinary legal manner before the ordinary court of land. So, rule of law implies that there must be absence of special privileges for a government official or any other person. Second, all the person, irrespective of status, must be subjected to the ordinary court of land. And third, everyone should be governed by the law passed by the ordinary legislative organs of the state. So, the rights of the people must flow from the customs and traditions of the people recognized by the courts in the administration of justice. But rule of law is criticized. The first principle of dicey rule of law is the recognition of cardinal principle of democratic government as opposed to arbitrary government, which lays down that no functionary of the government should be wide, arbitrary or discretionary power, as it will interfere with the liberty of the people. It will also interfere with the freedom of the people. But here Dicey was not referring to a wide measure of discrimination which is inescapable in any modern government. The second principle which he was given, that the democracy principle of equality of all persons should be there. But it is not possible for the ordinary court of land to administer all the cases. Dicey's insistence was that a government officer must be under the same liability for acts done without legal justification as a private individual. The third principle does not lay down any legal rule but merely explains one, an aspect of the British constitutional system where common law is the source of fundamental freedoms of the people. Thank you, everyone.